Professor Fletcher, imagine I'm a growing business, I'm successful, I've got an online presence, I'm doing lots of great stuff, I'm a challenger to the global big businesses. What does this bill mean to me? What difference will it make?
Well, I think it would make quite a lot of difference, but it would make quite a lot of small differences, and it would depend on the business that you were in. If you're an app developer, it would ensure, first of all, at the moment we have categories of rules rather than specific rules, so I can't actually say exactly what it would do. But for example, it could give you fairer access to app stores. It could, if you were a seller through Amazon, who we were talking about earlier, it could give you fairer access to your own data about your own sales. So I could probably talk for a long time about all the things it could do, but just to highlight that you are, in that role, exactly who the law is targeted at helping.
Yes, absolutely. Yeah, thank you. And I noticed we've lost one of our witnesses, but if I could go to, I think it's Professor Marsden.
No, Professor Furman.
Professor Furman, my apologies.
Yeah, you want to prevent things. Fair dealing, open choices, and trust and transparency are three of the main conduct requirements. They're all designed to make sure you couldn't have a search engine hiding searches from your business. You couldn't have them preferencing themselves and directing to themselves instead of to you. You might benefit from some of the interoperability and data access by being given access to the data or access to a system that you could operate on that right now one of your bigger competitors is doing. So I think it's both preventing harmful things and unfair things from being done to you, but also affirmatively opening up some options. And by the way, all of that's not just good for innovation, it's just good for the consumer because it will make things easier and more streamlined for them as well.
Excellent. If I may just follow up, spinning that question on its head to Professor Marsden. Hopefully I've got the right person, if you can hear okay. I was asking before about what difference would this make to a small business, a growing business, but for the big businesses, the sort of global giants in especially the online space who work in that space, what will this mean to them? What's it going to make them be better at doing, and what's it going to stop them from doing that might be harmful to competition at the moment?
Well, if I address that first, and then I'll go back to the appeal point if you'd like to hear my views on that. It's going to make these big platforms compete, basically for the first time. You will hear a lot of guff about how they're in some sort of oligopoly competition with each other all the time in areas, and some of that might be true, but they're not really. They really aren't, and we see that in the competitive structure of the market, we see that in the profits, the concentration levels, etc. We're not trying to reduce profits or anything like that. What we're trying to do here is allow others to have a chance. And that, if anything, like with open banking, will, I think, light a fire underneath some of these big platforms who are telling you they're innovative, and they are, but they're usually innovative in a way that makes you then more dependent on them. And we're not really all that fond of dependence in these markets. We're fond of diversity and choices, and allowing competition on the merits to rise and fall, products to rise and fall based on their merits rather than on whether or not they've satisfied the terms and conditions of a particular platform. On appeal, just briefly, and I'm so sorry for cutting out, obviously Zoom is perhaps not a platform with strategic market status, but anyway, I've heard many advisors to tech platforms that might be subject to this bill and legislation argue that the appeal issue is not just a small thing in the legislation, it's absolutely fundamental. Well, I'll agree with them in two things. One, the bill itself and the ex-ante approach that we've been discussing is absolutely fundamental. That is the big change. The change with respect to ex-post enforcement and the respect of the review of the conduct requirements, etc., and the investigations and anything that is imposed on the platform, that to me involves such an involved process between the platform and the digital markets unit and other entities, such an open participative process that gives me a lot of comfort about due process itself. And if anything, if there was an appeal standard, full appeal standard, we might as well just move to sort of a prosecutorial approach where the DMU is a prosecutor and everything's adversarial and everything takes 18 years in court. That's kind of what we've got now. So if anything, I feel this is an opportunity to really understand the business models, really understand and put bespoke requirements in, and to A/B test these remedies. That's a very important aspect. And also release remedies if they're not working or if they need to be tightened up. And that therefore shows internationally what the UK thinks about these practices, which might help with that sort of global spread that Amelia was mentioning. But I do have to say quite firmly that I do believe that judicial review takes a lot longer than a substantive appeal. And I do think that if the bill was amended to allow a substantive appeal, or even a few years of substantive appeal, then we might as well not have done the study at all, and you might as well not pass the bill with respect to digital arrangements, because it will just return us basically to what we've seen before. In contrast, the European Commission is allowing a substantive appeal right, and I think if anything that means they're going to code for prohibitions. You know, as Amelia said, the law isn't as bespoke. They're just going to say, here's a general obligation. Oh, I don't think you're satisfying it. And then there's an appeal up to court, and we wait 18 years for Luxembourg to rule. Here, those issues will be dealt with, hopefully, at the administrative stage. And then, of course, whether or not the authority of the DMU and the process itself was fair and reasonable is something that obviously the courts should review. And we welcome that scrutiny. If I was to be involved in any of this, I would very much welcome that kind of scrutiny at the judicial review level, which is a very intense form of review itself. And so I just feel that it's appropriate to have this JR standard. But I appreciate I've already heard a lot against that, and I will in the future.
Thank you.